Hello, viewers. In this episode of Tête-à-Tête, we discuss a rather sensitive issue, the issue of marital rape, an issue that is treated with an uncomfortable silence, not only by the perpetrator, but by the victim and society as well. Through this discussion, it is our endeavor to create awareness on the issue as well as the law relating to marital rapes in India.
So, marital rape is the act of any kind of sexual intercourse by a man with his own wife without her consent. Now, lack of consent is the crucial element in determining the marital rape. So, it is to be observed that such offenses involving the spouses is almost always committed on the woman or the wife who is in a relationship. Hence, there are also provisions under the law to consider it as domestic violence.
Not just in India, world over, physical relationships within the realm of a marriage was considered very normal. It was not considered an offense. Marriage being a legal contract, it was presumed that once a man and woman got into a legal marriage, the woman gave blanket approval or consent for everything that went into a marriage, including a physical or a sexual relationship. So, a marital rape was not even considered so and therefore was not recognized as an offense.
Correct. So, it was only from the 19th century when the feminist movement gained a lot of steam that such an offense came to light. So, by the 20th century, when protection of human rights became widely recognized and accepted, the demand for marital rape laws also gained a lot of traction. So, in the mid 90s, the United Nations even adopted a declaration of elimination of violence against women, which recognized marital rape as human rights violation. The Section 375 of the IPC deals with rape. Now, for the benefit of the viewers, we have put up on the screen a link containing the exact provision of the Section 375. Now, giving an explanation of this section, it simply puts that the section states that if a man is said to have committed a rape against a woman, if he inserts either any of his organ or any object into a woman's vagina, mouth, or urethra against her will, or without any consent, or by getting her consent through any ways of threat or intimidation of death, or when the man knows that he is not her husband, but the woman also gives her consent, believing him to be her husband when he is actually not. When she gives consent after being intoxicated, or if she's been administered through any kind of drugs in any of such way, the woman does not comprehend and she has given her consent. Now, also with or without a consent when she is under the age of 18 years. And also if she's unable to communicate the form of consent.
Right. But I think also the section had a couple of exceptions, right? If I'm not mistaken.
Yes. Yeah. So there are about 2 exceptions here. So when any medical procedure or intervention will not be considered as a rape. And the second thing is, if the sexual intercourse or any sexual acts committed by a man with his own wife, and the wife is not being under the 15 years of age, is not rape.
Subathra, it is the second exception that you mentioned that pretty much triggers the interpretation that marital rape is not an offense. See, as you mentioned, the exception states that any sexual intercourse between a husband and wife, if the wife is above 15 years of age, does not amount to rape. Right?
So this means that a sexual encounter between a husband and his wife who is above 15 years of age does not amount to rape.
Yeah.
Again, the point to be noted here is the exception does not mention about the consent of the wife.
Exactly. So it is exactly this exception to Section 375 that pretty much decriminalizes marital rape.
Correct. Now, coming to the amendments in Section 375 of the IPC, I would like to share that the core definition or the provision of the Section 375 was amended in 2013. So it was amended to include that not only penetration of male organ into a woman, but even the penetration of an object into a woman would be considered as a rape. So this amendment was included only after the horrific Nirbhaya case. In 2018, the section was once again amended to increase the imprisonment term from 7 years to 10 years to make it more stringent and to bring the perpetrator to the book. However, neither the amendment to the exception 2 was made nor was it altogether removed. It continued to remain.
One of the landmark judgments by the Honorable Supreme Court on issue relating to marital rape was in the case Independent Thought versus Union of India, which was decided in 2017. Actually, in this case, the Supreme Court was dealing with the issue of child marriage. It was not relating to marital rape, it was dealing with the issue of child marriage. However, it observed in the course of the hearing that exception 2 of section 375, and I quote from the judgment, is arbitrary, discriminatory, and violates fundamental rights of women and girl children under Article 14 of the Indian Constitution. So, while removal of exception 2 to 375 was not the main issue in this case, however, the honorable judges, they took on record that and then they read down the exception 2 of section 375. When I say read down the section, they interpreted it as sexual intercourse or sexual acts by a man with his own wife, the wife not being 18 years of age is not rape. The original exception said 15. They read down as 18. Okay. And this was primarily done to bring it in line with provisions of other stringent laws like POCSO, which recognized 18 as the age of being a major and not 15 as given under exception 2. Right? So,
Another judgment is the RIT Foundation versus Union of India. It is a Delhi High Court judgment. Here, the Delhi High Court clearly recommended the deletion of exception 2 of section 375 of the IPC, thereby making marital rape as a criminal offense.
Right. Also, I'd like to mention here that in the aftermath of the Nirbhaya case, the Justice J.S. Verma committee was constituted to make recommendations for changes in the criminal laws. And of the many changes recommended by the Justice Verma committee, a major change that was recommended was to expressly make marital rape an offense. Okay. However, several recommendations were accepted, but the recommendation on making marital rape an offense was not accepted, in the sense it was put on hold, as the then government was of the view that making marital rape an express offense may threaten the institution of marriage and probably also be a tool of misuse. And so the exception 2 to section 375 of the IPC continues.
So to sum up, in July this year, the Honorable Supreme Court had stated that it would hear a batch of petitions involving marital rape. So the key common issue to be dealt with here is the criminalization of the marital rape as such. So the outcome is eagerly awaited.
So, but whatever it is, Subathra, rape, there are unfortunately manifests as several kinds. There's date rape, there's gang rape, genocidal rape. No matter what term you give to that, it is rape is basically a violation of a woman's body without her consent. If we apply the definition of section 375 in simple terms, it means a forcible sexual intercourse without the woman's consent. So if that is rape, then it will be rape whether it is done within a marriage or outside of the marriage. right? So all eyes are on the apex court for the final outcome, and we'll all be eagerly awaiting for a very non-gender stereotyping sort of a judgment. Thanks for joining. We hope our viewers found this informative. Thank you.
Thank you.